Hello, my friend. Whether you have clicked on our videos for the first time, or you are a companion of our Academy's journey, you're interested in international law, and that's wonderful. My name is Walter, and I have the honor to represent IntlLaw Academy lectures about sources of international law. We have covered studying the primary sources of international law. If you want, you can find the videos about that in the playlist mentioned above. Now, we are moving on to the subsidiary sources of international law. So if you are eager to join us, let's begin. As we now reach the final stage of our journey through the sources of international law, we turn to what Article 38 of the Statute of the International Court of Justice calls the subsidiary means for the determination of rules of law, judicial decisions and the teachings of the most highly qualified publicists. Judicial decisions are not, by themselves, binding sources of international law in the same way treaties or customs are. Yet, they form the living memory of international law, precedents and guideposts that illuminate the path for states, judges, and scholars. When a legal rule is unclear or absent, international tribunals often turn to the reasoning of earlier courts to find direction and coherence. Over time, these decisions have built an intellectual architecture of their own. From the Permanent Court of International Justice in the interwar years to the International Court of Justice today, and even to specialized bodies like the International Criminal Court, the International Tribunal for the Law of the Sea, and regional human rights courts, judicial reasoning has given international law its rhythm and consistency. For example, the Barcelona Traction case, 1970, decided by the International Court of Justice, clarified the notion of obligations erga omnes, duties owed by all states toward the international community as a whole, such as prohibitions on genocide or slavery. In the Corfu Channel case, 1949, the court confirmed the principle that states must not knowingly allow their territory to be used for acts contrary to the rights of other states. And in the North Sea Continental Shelf cases, 1969, the court illuminated how customary international law is formed through consistent state practice combined with a sense of legal obligation, or opinio juris. The second category is doctrine, the realm of scholarly thought. Doctrine, or the collective reasoning of jurists and publicists, forms another vital part of international legal life. It represents the reflections, commentaries, and syntheses of the world's leading legal minds, works that help explain, systematize, and even inspire the evolution of international law when treaties and customs fall silent. Institutions such as the Institute of International Law, founded in Ghent, Belgium in 1873, have long provided this scholarly compass. So too has the International Law Association, originally called the Association for the Reform and Codification of the Law of Nations, established in Brussels in 1873, the American Society of International Law, created in Washington, D.C. in 1906, and of course the Hague Academy of International Law, founded in 1923, a beacon for generations of jurists and diplomats. These institutions collect, discuss, and refine the principles that underpin the discipline of international law. Within doctrine, we also encounter a number of famous doctrinal theories, ideas born from specific historical and political contexts, yet deeply influential in shaping international legal reasoning. The Truman Doctrine emphasized freedom from domination and the defense of independence, reflecting the moral stance of post-war America. The Stimson Doctrine declared that territorial acquisitions achieved through aggression could never be recognized as lawful. The Monroe Doctrine of 1823 asserted the principle of non-intervention by European powers in the Americas. From Latin America we see equally profound contributions. The Calvo Doctrine, developed in Argentina, held that a state bears no special responsibility toward foreign nationals beyond what it owes its own citizens, a principle that inspired the Calvo Clause, which limits diplomatic protection in investment contracts. We also have the Tobar Doctrine from Ecuador, linking recognition of governments to their legitimacy, and its evolution in the Betancourt Doctrine, which refined that idea by emphasizing democratic legitimacy as the basis for recognition. The Drago Doctrine, also from Argentina, opposed military intervention for the collection of public debts, insisting that financial disputes must be settled peacefully. Meanwhile, Mexico contributed the Estrada Doctrine, which rejected the practice of recognizing or de-recognizing governments as interference in domestic affairs. And of course, the Lauterpacht Doctrine stresses the obligation of states to recognize new states once the factual conditions of statehood are met, marking a milestone in the theory of recognition. Each of these doctrines reflects a distinctive vision of justice, sovereignty, and order, together forming the intellectual DNA of international law. The third supplementary source of international law is the principle of equity, sometimes called judicial fairness or discretion. Equity at its core represents the pursuit of justice beyond the strict letter of the law. It empowers judges to temper legal rigidity with moral balance, ensuring that the law not only applies but that fairness is achieved through its application. When international judges or arbitrators apply equity without the express consent of the parties, it is treated as an inherent part of law itself. In such instances, equity operates within the boundaries of established legal rules, filling gaps, complementing silence, or guiding interpretation. For example, Article 59 of the 1982 United Nations Convention on the Law of the Sea permits reference to equitable principles in maritime boundary delimitation. Here, equity is not just a moral guide, it becomes a legal norm, authorized and recognized by the Convention itself. Equity, then, functions as a complementary rule, ensuring that existing legal provisions are applied in a fair and balanced manner. It may refine, interpret, or adjust a rule to achieve just outcomes, but it cannot override or contradict established international law. At times, equity also serves as a tool in non-legal or political disputes where no concrete legal rule exists. In such cases, states may appeal to equity to reach peaceful or pragmatic solutions, provided that binding legal obligations are not at stake. There is a special form of equity invoked with the mutual consent of the parties. When states agree that a dispute should be settled ex aequo et bono, according to equity and good conscience rather than strict law, they authorize the judge to apply fairness in its purest form. This does not invalidate legal norms, rather it transcends them by mutual will, replacing rigid legal justice with the humanity of moral justice. In this way, equity is not merely a legal supplement, but a reminder of the ultimate purpose of law, that law exists to serve justice, not the other way around. The next supplementary source of international law is the Unilateral Act, implicitly recognized in Article 38 of the Statute of the International Court of Justice. Unilateral acts are statements or actions by a state or international organization that create legal obligations through their own expression of will. When such acts are undertaken with the intent to produce legal effects, they can bind the issuing state or organization, and in certain circumstances may affect the rights and obligations of others. For a unilateral act to be legally binding, several conditions must be satisfied. It must be independent, lawful, reasoned, and expressed through a formal declaration or promise. These acts may derive from customary or treaty obligations, or appear as optional or mandatory notifications related to those frameworks. Importantly, unilateral acts do not require acceptance or reaction from other subjects of international law to take effect. Unilateral acts appear in multiple forms. At the state level, they include recognition, for example, acknowledging a new state or government; protest or silence, through which a state may create, affirm, or renounce a right or obligation; declarations or notifications, by which a state clarifies its position or intent under international law. Within international organizations, unilateral acts often take the form of resolutions, general and collective instruments adopted by organs of the organization. Resolutions can be operative, such as UN Security Council resolutions authorizing enforcement actions; declaratory or standard setting, articulating or confirming existing norms of international law. Other forms of unilateral acts within organizations include decisions, binding acts, recommendations, persuasive but not legally binding, declarations or statements, carrying political rather than legal weight. These acts may be intra-organizational, regulating the internal affairs of the institution, or inter-organizational, shaping its relationship with other actors in the international community. A further dimension of unilateral acts arises through the statements of state officials. When made by high-ranking representatives, such as heads of state, heads of government, or foreign ministers, these statements can legally bind the state, provided they fall within the speaker's competence and are made with genuine intent to create legal effects. Statements by lower-ranking officials, in contrast, are binding only within the limits of their delegated authority. However, not every statement constitutes a binding unilateral act. To have legal force, a declaration must reflect a real and deliberate intent to commit the state under international law, be addressed to the international community, be consistent with the state's prior conduct and legal obligations. When such declarations conflict with existing treaties or norms, their legal rank depends on interpretation. Are unilateral acts mere expressions of political morality, or do they stand as independent sources of legal commitment? The answer determines their place and authority within the international legal order. And now, we come to the final supplementary source that deserves special attention, the realm of informal agreements, often referred to as soft law. In international law, we can broadly distinguish between hard law and soft law. Hard law refers to the binding set of legal norms whose violation gives rise to international responsibility and constitutes unlawful conduct. Soft law, by contrast, includes instruments whose non-compliance does not amount to an unlawful act and does not produce direct legal responsibility. The two categories are distinct yet complementary, and informal agreements, such as declarations, guidelines, codes of conduct, or memoranda of understanding, fall within the soft law domain. Informal agreements can take various forms. 1. Political informal agreements. Commitments between states to pursue common policies or coordinated actions without creating legally binding obligations. Example: the Atlantic Charter, 1941, between the United States and the United Kingdom. It outlined 8 guiding principles for their relations during World War II. Though not legally binding, it carried immense moral and diplomatic influence. 2. Procedural or supplementary informal agreements, designed to overcome deadlocks or clarify conduct within a larger institutional framework. These are often annexed to formal treaties as complementary instruments. Example: during the Third United Nations Conference on the Law of the Sea, states adopted an Honourable Gentleman's Agreement on internal voting procedures, informal but politically crucial for facilitating progress. 3. Normative informal agreements, closely resemble treaties in substance but lack binding force. Common in international economic relations. Examples: the OECD Declaration on International Investment and Multinational Enterprises, the Paris Club, SE 1956, which restructures developing countries' debts through non-binding yet influential understandings. These forms demonstrate how soft law shapes state behavior and complements formal legal instruments, even without producing direct legal obligations. Informal agreements have also shaped the political and security architecture of entire regions. The Yalta Agreement between the United States, the United Kingdom, and the Soviet Union, which determined post-war Europe, began as an informal political understanding. Similarly, the Helsinki Final Act, 1975, and the subsequent Charter of Paris for a New Europe evolved from informal commitments into the institutional framework of the OSCE, Organization for Security and Cooperation in Europe. Though lacking the formal binding character of treaties, informal agreements function as powerful instruments of coordination, norm creation, and consensus building. They form the flexible tissue connecting the rigidity of hard law to the living practice of states, ensuring that international law remains responsive, adaptive, and dynamic. My dear friends, with this final discussion, we have reached the end of our long and enlightening journey through the sources of international law. From treaties and customs to general principles, and finally to the supplementary sources, we have explored together the very foundations upon which the international legal order stands. I want to sincerely thank each of you for walking this path with me, for your curiosity, patience, and passion for understanding the law that governs our shared world. It has been an honor and a joy to travel beside you, to see how our collective curiosity transformed abstract norms into living knowledge. Wherever you are watching from, I hope that your love for justice and international law never fades, that it continues to guide your thoughts and inspire your dreams. And I promise, whenever destiny allows me this privilege again, I will return with new stories of new questions and new horizons to explore with you. Until then, keep your minds open, your hearts steady, and your passion for law alive. This is Walter, signing off with gratitude, respect, and the hope that we shall meet again on another chapter of the IntlLaw Academy.